Yes, my name is Simon Allison. I'm originally from Australia, where I previously worked in state and federal government there, and then I started my law studies at the University of Western Australia. I then did an MPhil in law, and then I moved to Cambridge to start my PhD in international law. I have quite a passion for public and private international law, and often how private law, both doctrines and processes, can actually achieve public policy ends, sometimes better than purely public systems. And so my PhD looked at the use of armed guards in counter-piracy activities, and compared the traditional orthodox state-focused system with its limits, its rigidities, its inflexibility, and then compared it to what it effectively become a sort of this growth of this sort of transnational law of with focusing on supply chains and commercial and assurance relationships, and where those relationships, for different reasons, often became quite good or potential enforcers of what are public policy objectives. So today I just want to talk a bit about that, and in that light, a very exciting new prospect, this notion of human rights, business and human rights arbitration, and which is human rights at sea are now trying to work on for that, the maritime context. So, but let's just talk about, this sort of a broad notion of accountability, which is not really a legal, it's not really an old school legal term, but I think, when we're starting to look at different ways law and economic pressures can be applied, it's quite a useful term. And I mean, if you speak to a traditional public lawyer, a lot of this stuff is, even some of the law stuff, they'll say, well, it's not law. But if say a points from a guideline end up in a commercial relationship that's subject to adjudication before courts, and that can result in a remedy, that's law. How it got there was a bit interesting, but to write some of these things off as just being soft law or just voluntary, when in many cases they're not really that voluntary. For a shipping company, what its underwriters and what its P&I clubs expect of them, they are commercial mandates. So I had to have these couple of quotes here to start off this thinking, this broad accountability, and how it's sort of it's a bit agnostic. It doesn't require, it's not purely private or public, it's an all-encompassing. So, I mean, the embarkation of private armed guards on commercial ships, primarily off Somalian coast, provided a unique opportunity to test the bounds of international law. Somalia represented a potent combination of a failed state with a large and difficult to patrol and very strategically vulnerable coastline. The use of private armed guards gave rise to concerns under public international law regarding law of the sea, shipping safety and safety of life at sea in particular, as well as human rights concerns. For example, the potential use of force by PCASP, the acronym for armed guards, has the capacity to cause legal and practical problems, such as excessive use of force causing death or injury, such as the Avazet incident, the use of force causing damage to ship or cargo and to other vessels, pollution incidents arising from damage to ship or cargo from a stray bullet on a parcel tanker, or the unlawful usurpation of master's authority, which is a very fundamental concept in law of the sea, negligence resulting in a vessel being taken by pirates, the use of unlicensed weaponry or weapons of war, the use of force resulting in an obligation to rescue those in danger, and then issues about failure to report the threatened or actual use of force. So, the use of armed guards officer tested the ability of the law of the sea framework enshrined in UNCLOS to respond to this type of activity. As non-state actors acting outside conflict zones, there was no support for the application of international humanitarian law norms to that. So the weight of discussion on this point was that it was hard to establish direct state responsibility, and I guess it was in that context that flag state due diligence became quite a key evolving and important evolving concept, that those obligations required at a minimum mandatory reporting, investigation of excessive use of force, and the provision of detailed guidance for the use of force by PCASP. So while it's not true to say international law had no rules, and it did have some substantive norms relevant to the embarkation of armed guards, targeted regulation was lacking. Applicable rules had to be distilled from a variety of legal worlds: international, domestic, public and private. Ship owners, underwriters, P&I became alarmed at the potential vulnerability of their commercial arrangements on grounds of illegality in public policy and their potential liability stemming from the use of force. This is very much Peter's work, but the lack of targeted, so we start to see the limits of the public, and then we start to see the move to sort of tease out more private ways of still trying to achieve the same public policy goals. The lack of regulation motivated shipping and insurance industries to develop regulatory initiatives, including ISO 28007, the standard, the standard contract for the use of armed guards on vessels by BIMCO, and the 100 series rules as to use of force as a sort of code of conduct that could be annexed to GuardCon to inform those RUF type requirements. These instruments incorporate the international norms concerning the law of the sea and human rights law and commercial shipping and insurance arrangements. They essentially they took advantage of those relationships inherent to maritime trade to infuse those agreements with norms that have a fundamental public policy nature to them. Despite their public policy character, they're incorporated through private law doctrines such as contract, torts, insurance law, etc. This is what Robert Y would call the touchdown effect. They could take advantage of private law mechanisms to embody those principles and provide dispute resolution. It was no longer complicated by questions of public enforcement, issues such as maritime zones, the complexities you get with public enforcement, so maritime zones and nationality and overlapping jurisdiction. The private law stuff is a lot more simple. Contracts can be breached anywhere. You don't have to sort of, when you're looking at, has a insurance contract or a carriage contract or a security contract being breached, you don't have to start worrying about where you are on the 12 nautical mile or the high seas. Private law can just be a bit more flexible in quite a useful way. So this novel adaptation of principles of international and public law it struck me as very much as sort of a Trojan horse, a very effective one. Maritime insurance industries are well accustomed to standard form contracting and standardization. They take advantage of, so to be able to take advantage of the forms to which industry was so familiar and so comfortable with, but to use them in this new way. This could give legal teeth to international legal norms in otherwise unpoliced environments, with private parties having the capacity to hold each other to account. So, and in the event of breach, gone were complicated questions of public international law and enforcement. Other things such as who could bring an action for breach of public international law, where such an action could be brought, against whom could it be brought, and the difficult issue of remedies, which is far from simple in public international law. But the use of private mechanisms meant private enforcement could take place. There was a more forward-looking approach. Commercial relationships set out these mechanisms early, providing certainty. They're well known, unlike the more complex, inherently retrospective nature of international dispute settlement in public international law. And there's reasons why this form of private ordering shouldn't be immediately dismissed as some sort of self-serving self-regulation. These players are for-profit players. However, it's important to remember that unlike some forms of self-regulation where one industry sets, monitors and enforces rules in a way arguably best suited to their commercial interests, in a broader supply chain and reinsurance environment, there's an important diversity of commercial interests. Insurers and P&I clubs favour reducing claims. Ship owners want to protect their club membership and registration and have an interest in following and enforcing rules that insurers insist on. Moreover, ship owners have an interest in contracting highly trained and certified armed guards and not potential cowboys that could put them in legal peril or even endanger their ship, crew, or cargo. Ships also need to make sure they can enter ports and conduct their business, thus requiring the requisite insurance certificates. And quality contractors and other members in these networks can have a commercial interest in enforcing rules and being distinguished from bad players in. So let's say there's sort of the internal and the external, and they can both be quite interesting in terms of monitoring and potential enforcement of public policy by private players. So let's just, I've just, in say commercial network, I've just picked the security providers here as being the subpart in this particular arrangement. But if you look here on the right, the potential impacts that can a below par provider can have on, you know, the services contractor for reputational loss by the other players, their potential civil and criminal liabilities or increased insurance premiums. These other players, they may not be die-hard human rights activists, but that they don't necessarily need to for a certain degree of monitoring enforcement that can happen that is conducive to the public good. So, and then we have the outsiders. So, you know, human rights abuses, loss of life and limb, economic loss, potential environmental damage. So this is where, so what we've seen, and the work Peter and his colleagues did with those documents show just how effective using private instruments and private mechanisms, private doctrines can be to achieve public policy good. And my assessment, it was an utter success. It is absolutely brilliant. So the question is, what could be the next step here? So let's have a look at another mechanism that industry is familiar and comfortable with, and that's international commercial arbitration. It's, for those, most of you would be aware, but to just quickly, international commercial arbitration is a very, very important alternative form of dispute resolution. It's based on consent. It's based on an arbitration agreement, often called the midnight clause, because people don't really think too much about it when they put together a contract, and it only starts to get attention when things go wrong. And it provides for arbitration that, subject to a small number of exceptions, can't be appealed to court, can't be retried in court, subject to some exceptions. And arbitral awards are enforceable, courtesy of the New York Convention, anywhere in the world. It's arguably a lot easier to enforce a foreign arbitral award than it is a foreign court judgment under conflict of laws. So I've just put some basic information there on just, now this is the really interesting step here. So this is not actually that old. In 2019, the Hague Rules on Business Human Rights Arbitration were introduced. The rules highlight the importance of collaborative settlement mechanisms in business and human rights disputes. Unlike institutional rules, the Hague Rules encourage parties to endeavour to resolve any dispute in good faith through collaborative settlement mechanisms. As part of that, in a Hague Rules arbitration, the award must state the reasons it was based and satisfy itself that the award is human rights compatible. This must mean that the award must accord with internationally recognised human rights and must also conform to public policy requirements under law of the sea and likely places of enforcement of the award. And if you go back to that thinking of the internal and the external situation, so they're the two, just the two key circumstances where you've got, for reputational or whatever, you've got internal enforcement, and then potentially extending it to third parties. What I'm just going to show you here, so this would be, say, for an internal type thing, an arbitration agreement that allows that arbitration to be done with those principles in mind. But in terms of third party, this is even more interesting as a model clause. If you just have a quick look at this, this potentially opens the door to redress for third party for human rights violations that just doesn't exist under public international law, or is just impossibly hard to give effect to. Interestingly, if you look here at
I'm sorry, can I make a point to Chris? Chris, if you can look at the time. I think
yes.
Just timing, please. It has to be finished very soon. I'm sorry, Dr. Allison. Doctor, sorry.
No, I've nearly done. So I just draw your attention to the bit in blue, and you can see how this type of clause would be able to bring in things such as the 100 series RUF, 28,007, etc. And so it's a very interesting. So the next step is getting. This is why we need to get that model to work and get it working at sea. And it's this. The white paper was done last year. And yes, thank you.